Hello and welcome to Monday. I hope you guys had a great weekend. I joke with you often. I hope you got a great rest and lots of sleep. I know it's wishful thinking, but I hope you had a safe and enjoyable weekend. Hope something made you smile. I hope something was enjoyable. I hope it was more than boring, and I definitely hope it wasn't miserable. But I hope it was a great weekend. We're glad you're back here. We're glad you're safe. Well, we continue today in our conversation about Article 3, the judicial branch. And today we're considering judicial review. What is judicial review? How did we get to a place of judicial review? And I hope that by the time this class is over today, you're going to be confident in knowing what judicial review is and how we got there. So if you've not already taken a few minutes to work on some vocabulary, your list is there on your PowerPoint. Hopefully you have that up in front of you. And if you would take about 10 minutes to work on that and then come back and we'll talk together. Okay, welcome back. You see there on slide 13, at least it's my slide 13, that federal judges are appointed by our president. State judges are elected by the voting population. Take a few minutes and consider what is behind that. Why are federal judges appointed and why are state judges elected? And what are the strengths of appointment and what are the strengths of election? What are the weaknesses of appointments and what are the weaknesses of election? There's a lot of them, so I hope you guys spend a few moments talking together and then share as a class what you've talked about. Okay, welcome back. Let's talk about the foundation of judicial review. We have to go way back to the case of Marbury versus Madison. And you have already had a conversation about Marbury versus Madison on Wednesday before homecoming. But if you don't remember what that case is, there was a transition between President Adams and President Jefferson. And Adams appointed a bunch of federal judges because he was concerned as a Federalist that Jefferson was going to appoint a bunch of judges that were going to be anti-Federalists, and he did not want the strength of a centralized government to be undone. So he appointed a bunch of federal judges, even created some new federal positions and appointed them too. And Jefferson comes on the scene, and he would not give them the documentation that they needed in order to actually take the bench as a judge. So there was a lawsuit filed in order to force Jefferson to give the documents that were needed so that the Adams-appointed judges could take the federal bench. So the Supreme Court would not force Jefferson to do that, but they did say that they had the right to engage in judicial review. So what that means is that the Supreme Court has the right to act on any executive order and any legislation of Congress. So the Supreme Court set themselves up as a radical influencer over legislation from Congress and executive orders from the executive branch, the president. So interestingly enough, the phrase judicial review is not in the Constitution. It was one of the largest cases at the start of our founding, though, that gave judicial review to the Supreme Court by the Supreme Court. So I'd really be interested to hear what you have to say, because on one side, the Federalists strengthen the role of the federal government by the appointment of federal judges, but on the other side, there's this taking away from the president and Congress by the Supreme Court. They take power away from those two branches and bring it to themselves. Excuse me. So talk about the impact of this case and what it might mean even today as it relates to judicial activism and the power of judges to declare things, laws and executive orders unconstitutional. So again, talk about the significance of this case. And do you think the Supreme Court should have the power to rule laws unconstitutional and executive orders unconstitutional? All right, welcome back. I would love to have heard that conversation in class today. But you see here how cases reach the Supreme Court on the next slide. And you understand there that Supreme Court either has original jurisdiction, again that's rare, or appellate jurisdiction. And original jurisdiction, again, is going to be something significant, immediate. It requires immediate action by the Supreme Court. Those are rare. More often, they act as an appellate. So it would start in a district court. A case would start in the district court, go to the federal appellate court, and then work its way to the Supreme Court. Now, you can see there that there are more than 10,000 cases a year that are appealed to the Supreme Court. However, they only take a small handful of those, around 80 cases per term, to actually hear. And in order for a case to be heard by the Supreme Court, 4 Supreme Court justices have to listen to the appeal and agree to take that case on appeal. So it's called the Rule of 4, and that will be on your test, the Rule of 4. And the Rule of 4, again, is that 4 Supreme Court justices agree that this is a case worthy of the Supreme Court listening to. Following that rule, and if they decide that they are going to hear the case, they issue what's called a writ of certiorari. That means that the Supreme Court mandates that all lower courts surrender to the Supreme Court all the documentation, all the transcripts from the previous hearings, and that way they have all that information so that they can ask questions of the attorneys that present the case to the Supreme Court, and they'll know exactly what it is that's going on. Now, last week we said we asked if there was a Supreme Court Supreme Court decision that you thought was wrong. We did that whenever we were in homecoming week. We had all those cases around the room, and a couple of them we were asking about whether or not the Supreme Court made the wrong decision. So now what we want to do is we want to ask the question, is there something that's illegal or legal that you would love to see the Supreme Court act on? We've talked about this from a congressional perspective, but the Supreme Court has the power to say that whatever it is that the Congress has done or what laws they've made are unconstitutional. So I don't want you to think about this in terms of law. I want you to think about this in terms of Constitution. Is there anything that's illegal that the Constitution does not prohibit? And is there anything legal that you think the Constitution should prohibit? So, and that the Supreme Court should act on that. Talk about that together. I wish I was here to hear that conversation. Talk together and then share as a class. Okay, welcome back. Last thing for today is the difference between a majority opinion, a concurring opinion, and dissenting opinion. Again, these things are going to be critical for you. They will be on your test. The majority decision, you know there are 9 Supreme Court justices. So the majority decision is at least 5 Supreme Court justices agree about the constitutionality related to a case that's brought before them. And they issue what's called a majority opinion. One of the justices will write that opinion on behalf of all 5, at least all 5, and then, or however many in addition to 5 there are, and all of those justices will agree to everything that is in that majority opinion. Now, let's just say 6 justices agree that a particular party should win the case, but that there's something in the majority opinion that one of those justices doesn't want to be in it. And so what they can do is take it out of there, and then all of the other justices, everybody will agree to that, but then a concurring opinion can be placed. So a judge can add to the majority opinion to strengthen the opinion of the court, even though some of the other justices might not have agreed to that. So again, it's a majority. The majority opinion, they all agree. A concurring opinion strengthens the agreement, but not everybody agreed to that. Now, interestingly enough, sometimes the dissenting opinion has been used in the future to say that there might be something wrong about this case that needs revisited in the future. So, even Plessy-Ferguson, the whole separate but equal, the dissenting opinions around that could be used as a foundation for like Brown v. Board of Education. So we find lots of times in case law that the dissenting opinion is used to overturn an opinion in the future. Excuse me. So the dissenting opinion is written by the Supreme Court justices that disagree with the majority. The majority wins, but the dissenting opinion is written by those that didn't win the opinion, and the Supreme Court justices write that with the hope, ultimately, that the dissenting opinion will form a foundation for a change in the court's position in the future. So you'll see lots of times that the court is not unanimous. Sometimes they are, but more often than not, we have a majority opinion where everybody that's on the winning side agrees, a concurring opinion that not everybody on the winning side agrees, but somebody wants to strengthen the opinion of the court, and then the dissenting opinion is the losing side, but it's the hope that it might change the ruling in the future. Well, that's all for today. I hope you guys have had some great conversation. I want to remind you I'm not there. I hope you know that you matter. And we care about you, we value you, and I hope you are having a great day. We look forward to seeing you soon.